Okay, welcome Auntie, welcome everyone to this event that was organized very last minute. So we are absolutely thrilled to have such wonderful participation, both from the U of T community and beyond. For those who don't know, my name is Amanda Carling. I'm Métis from Manitoba, and I'm the manager of Indigenous Initiatives at the University of Toronto Faculty of Law. And I am thrilled to have organized this event with the members of the Indigenous Law Students Association. And in particular, I wanted to send a special shout out to Carly Nordstrom for her leadership in this event and with the Indigenous Law students more generally this year. I want to start by acknowledging that the University of Toronto operates and occupies land that has been cared for thousands of years by the Huron-Wendat, the Seneca, and our very good friends, the Mississaugas of the Credit River. Land acknowledgements can be, in some circles, quite controversial, but I want to invite everyone who's here to think throughout this event and reflect on the land that's supporting you right now. You might be in Takaranto or you might be elsewhere in the world. This event is about land, and it's about our connection to land as Indigenous people and how that land is tied to our survival. I'd like to thank the Law Foundation of Ontario for supporting this event and the Indigenous Initiatives Office more generally. This is part of the IIO Speaker Series, which would not be possible without the Law Foundation, so thank you to those kind folks. Again, so we've already, for those who were here a few minutes ago, we've talked a little bit about how questions are going to be asked, but just quickly in terms of housekeeping, if you are able, please have your camera on and your microphone off. If you are not able to have your camera on, that's totally fine. We don't want a New Yorker type of situation to happen at this event. We are recording, but unless you speak, you won't be recorded, so you don't need to worry about that. There are times we are going to open the event to questions. So as I mentioned earlier, please indicate in the chat function, I have a question or something more creative along those lines. And when it's your turn, we'll invite you to unmute yourself and ask your question. So with that out of the way, the plan for the next 2-ish hours is as follows. I'm going to pass it over to Elder Constance, and she's going to open this event in a good way. Then you're going to hear from Lavely Forbes, who's an outstanding second-year law student and a member of the Indigenous Law Students Association. And then you're going to hear from our very special guest, Angela Delia, I'm so sorry, Angela, if I'm pronouncing your name wrong, Decembrini, who is a lawyer with First Peoples Law based here in Toronto and is also counsel for the community that we are all here to support today. We'll have a bit of time for questions, and then at about 5 to 1 or 10 to 1, we're going to take a quick break before we start part 2 of the event. So Carly and ILSA members, unless I missed something, I'm going to hand it over to Elder Constance. No? Speak now. Okay, I see a thumbs up. Okay, Auntie, I can't see you, so I'm hoping that you're there. Please unmute yourself.
I'm unmuted. Why can't you see me?
I can see you, Elder Constance. Amanda just doesn't have your video pinned, but you look beautiful. It's lovely to see you.
Oh, miigwech, thank you. And we say to you, bonjour, tansei. Ani, and offer to you a warm welcome and thank you that you would join your hearts and minds together as we lift up the Mi'kmaq people. And I would like to open with a prayer. As you can see, I've got the medicines burning. And thank you to our special guests who are willing to come and give of their time and speak their words of wisdom. So Creator, I'm offering this tobacco to you to thank you for this day, to thank you that each day is a new beginning and therein lies our great hope as human beings. Thank you, Creator, for all the lands of Turtle Island, all the sacred territories, the First Nations and Inuit and Métis people across Turtle Island. And we are speaking to you today from the sacred territories of the Mississauga of the Credit, a great gathering place for the Huron-Wendat, the Haudenosaunee, the Anishinaabe, and the Métis peoples. And lighting these sacred medicine to set this intention for this meeting, which is to join our hearts and minds, to lift up our brothers and sisters, not only in a show of solidarity, but with our prayers, for we know, Creator, that you hear prayers. I ask the ancestors of the Mi'kmaq nations to walk with them, to guide their footsteps. And I acknowledge before you, Creator, that we all stand in the footprints of our ancestors, and therefore we have these ties with these lands and these ties with one another. I would ask, Creator, that you would bless our guest speakers here today, that they would be relaxed, that they would speak from their heart in their authentic voices, and bless us all with their words of wisdom. I thank you, Creator, for this sacred water that sustains all life, this sacred water that brings our children to us, this sacred water that is our tears. And in the shedding of those tears comes about mental health and wellness. It also ties us one to another as human beings. So I say, Medut, Chimigwich, Matakriyosh, all my relations. Hi.
Merci, Auntie, thank you. Lava, over to you.
Great. So good afternoon, everyone. For those of you who don't know me, my name is Lavely Forbes, as Amanda said, and I'm a second-year law student here at U of T. I want to thank you all for coming to this information session, and I would like to thank our speakers for joining us today. This issue is one that's particularly close to home for me, as my family is from the Maritimes, and I have Mi'kmaq ancestry from Newfoundland on my mother's side. Last year, ILSA organized a teach-in on the Wet'suwet'en conflict. At that event, I brought up the fact that at the heart of that issue was the centuries-old conflict over the right to Indigenous sovereignty. Today, looking at what is happening in Nova Scotia, we can see that although this issue is about treaty rights rather than Indigenous governance per se, it is founded upon the same underlying conflict. Treaty rights find their basis in the original occupation of the land that is now called Canada by Indigenous nations, and are a product of nation-to-nation negotiations between Indigenous nations and the Crown. They presuppose Indigenous sovereignty, but are rarely interpreted by the Canadian government or legal system as such. As we will be learning about in more depth during Angela's presentation, the Mi'kmaq Nation signed peace and friendship treaties with the British Crown back in the 18th century. They were in agreement to live together peacefully, not to surrender land or self-determination to the British. In the 1999 Marshall decision, the Supreme Court of Canada confirmed that based on these treaties, the Mi'kmaq Nation had the right to earn a moderate livelihood selling their catch without a commercial license, and that they had the right to fish year-round. Even though this right was affirmed by the highest court of the country more than 20 years ago, it is yet to be protected by the federal government. The launch of the self-regulated lobster fishery by the Sipekne'katik Mi'kmaq Nation this past September signaled to both the government and to the rest of Canada that Mi'kmaq fishermen were going to exercise their right to earn a moderate livelihood, whether this was going to be respected or not. Despite there being no evidence that this fishery would be unsustainable, non-Indigenous fishermen continue to launch violent attacks on the Mi'kmaq people and their property. These acts of violence demonstrate both the ignorance of treaty rights on the part of non-Indigenous Canadians and the extent to which racism continues to define the relationship between Indigenous and non-Indigenous Canadians. Racism is an integral part of the Canadian experience. It is taught to children by parents and teachers, and it's reaffirmed by our legal and political institutions. It weaves its way into our literature, our pop culture, and our history classes. And for the most part, it goes unnoticed by those who are not victimized by it. Racism in Canada is insidious. It hides between the lines of pages and can be found as much in what is said as what is left unsaid. When I went to Morocco on exchange in undergrad, I was struck by the way the international community regards Canada. I remember my mostly European classmates enthusiastically congratulating me and the other Canadians for being from Canada, as they shared stories about how nice Canadians were. They all knew how Canada had been formed, and they found no issue with it. The colonization of the Americas had been taught to them the same way it was taught to me in elementary school, as a benign and even brave enterprise carried out by explorers seeking new worlds. Our real history tells a story of genocide and broken promises. While the treaties signed between the Crown and the various Indigenous nations set out the terms according to which the nations would be able to live in peace with one another, these treaties were more often than not seen as nothing more than bargaining chips to bolster settler expansion. The Crown has time and time again failed to uphold its end of the bargain when it comes to implementing and respecting treaty rights. For a country that prides itself on the rule of law and the respect of rights, it does not seem to have much difficulty brushing aside constitutionally protected treaty rights, even after these have been affirmed by the Supreme Court of Canada. The ignorance of those who believe the Mi'kmaq have no right to fish out of season to earn a moderate livelihood is not accidental. It's a product of careful design. The lack of education most Canadians receive on treaty rights is likewise not a mistake. It's a choice made by parents to not inform their children, by school boards and universities to not inform their students, by politicians to not inform those they represent, and by individuals to not inform themselves. As law students, we learn about treaty rights and constitutional law, and to a certain extent in other courses as well. However, this topic should not be treated as merely another topic covered in our legal education. Knowledge of and understanding of treaty rights is something that all Canadians should know about, since we are all bound by treaties by virtue of our status as Canadian citizens. We are all treaty people, and we all must live together. The current Mi'kmaq fishery dispute is proof of what happens when widespread ignorance of treaty rights combines with government inaction. That's why I'd like to thank you again for coming out to learn from people who know far more than me and who have kindly agreed to present to you all today. Thank you, and I will now hand it over to Angela.
Thank you so much, Lavely. I think your introduction really provides good context for some of the things that I'll be talking about. Thank you as well to Elder Constance for the blessing, and just thank you for the invitation to speak. It's really a privilege to do so. I graduated from U of T Law in 2003, so it's exciting to be back here even if it's virtually. And I'd also like to state that the statements I make today are based on my own views on this issue and not those of Sipekne'katik First Nation. So it's been more than a month now since the Sipekne'katik launched its self-regulated commercial lobster fishery. And over the past month, we've seen Mi'kmaq fishers accused of operating an illegal fishery, being subject to violent attacks, acts of vandalism, at the hands of non-Indigenous commercial fishermen, while federal and provincial government threatened to prosecute individuals purchasing lobster caught as part of the fishery. So while the media has largely characterized that dispute as one between the Mi'kmaq and non-Indigenous fisheries, in reality, the events really, as Lavely, as you mentioned, really are the result of the Crown's failure to recognize and implement Mi'kmaq commercial fishing rights. So for today's discussion, I thought I could provide a high-level overview of the historical context giving rise to the current conflict, including the Supreme Court's decision in Marshall, then address some of these misconceptions about Mi'kmaq commercial fishing rights, and then briefly touch on some of the more recent events that have happened in the last few days as a way of highlighting some of the issues that we might anticipate going forward. So I'll try my best to keep my comments brief so that we can open up the discussion. So again, at the heart of the current conflict really is this fundamental misunderstanding by many Indigenous people about the nature of Mi'kmaq's inherent and constitutionally protected fishing rights and the Crown's failure to implement those rights. The Mi'kmaq in Nova Scotia, like other Mi'kmaq in Canada, have constitutionally protected rights to fish and to sell their catch. And these rights are rooted in their own historical practices that have sustained the communities since before contact. These rights are acknowledged and set out in the peace and friendship treaties that were entered into between the Mi'kmaq and the British Crown in the 18th century. And really, as Lavely mentioned, these peace and friendship treaties were diplomatic agreements between the Mi'kmaq and the British Crown and the British. They were meant to solidify alliances, between the two nations and ensure peaceful relations going forward. And trade was one of the ways that by which the British established and maintained peaceful relations with the Mi'kmaq. So historians have noted that trade and peace really went hand in hand. So for this reason, the peace and friendship treaties also recognize the ongoing trading relationship between the Mi'kmaq and the British. And the Mi'kmaq have a long history of trade and alliance, first with the French and the British. And I think knowing that history is really important to understanding the origins of the relationship between the Mi'kmaq and the British and the intention of the parties in entering into the treaty. The Supreme Court has summarized some of that history in Marshall when it recognized Mi'kmaq commercial fishing rights as being protected under Section 35 of the Constitution Act, 1982. And I'll get into more details about the decision and its implications, but just a reminder that as you all know, that was in 1999. And since that time, the Crown has been reluctant to engage in meaningful good faith negotiations with the Mi'kmaq to implement those rights. So it's against that backdrop that the Sipekne'katik decided on September 17th to exercise its constitutionally protected rights and commence a commercial lobster fishery. As part of the fishery, licenses were issued and lobster trap tags were issued to a handful of Mi'kmaq fishers. These licenses permit those fishermen to catch lobster and sell it pursuant to their commercial fishing rights. In response, as again we're aware, members of the non-Indigenous commercial fishery organizations took the position that the Sipekne'katik was not authorized to launch its own self-managed commercial fishery because the fishing season was closed under federal law. And they claimed that the fishery was illegal, and we know how they've responded. So again, we can talk a bit more about that later on. So the Marshall decision. In Marshall, the Supreme Court of Canada recognized that the Mi'kmaq have a constitutionally protected right to fish for a moderate livelihood. So what this means is that in addition to their right to catch the fish, the Mi'kmaq have a constitutionally protected right to sell that fish to support themselves and their families. So in Marshall, a majority of the court held that the Peace and Friendship Treaty of 1760 affirmed the right of the Mi'kmaq to provide for their own sustenance by trading the products of their hunting, their fishing, other gathering activities in exchange for what was referred to in the treaty as necessaries, and which the court found was equivalent to a moderate livelihood. So while the court didn't define moderate livelihood, it did explain that it was something more than just subsistence. In the particular facts of the case, Donald Marshall Jr., a Mi'kmaq man, was charged under federal fisheries regulations for catching and selling eel with an illegal net and without a license outside of DFO's regulated season. He admitted to doing so, indicating that he was doing so to support himself and his wife, and that he was doing so in accordance with his treaty right. So a treaty right which exempted him from compliance with the regulations. The Supreme Court agreed that he had established a treaty right which permitted him to fish for eel as a small-scale commercial activity to support him and his spouse. And I think it's important to note that the nature of the right recognized by the Supreme Court in Marshall is an existing commercial fishing right recognized by the 1760 treaty. And the reference to moderate livelihood serves as only serves as an upper limit to that right. So this is the right that the Mi'kmaq fishers in Nova Scotia are exercising through their commercial lobster fishery. So with that context in mind, I thought I'd just try to address some of the misconceptions that have arisen in response to the Mi'kmaq fishery. First is the claims of an illegal fishery. So as I've mentioned, non-Indigenous commercial fishery fishers have claimed that the Mi'kmaq are engaged in an illegal fishery. And they say this because the fishery is taking place outside of the fishing season that has been established by DFO by way of regulation. So again, though, these claims stem from a misunderstanding about the nature of the Mi'kmaq commercial fishing rights. The right of the Mi'kmaq to engage in the commercial lobster fishery is based on their constitutionally protected Aboriginal and treaty rights. Those are the rights that were recognized by the Treaty of 1760 and by the court in Marshall. And they are not dependent on the Crown's legislative authority. So that's really the key here. Canadian courts, including the court in Marshall, have held that the Crown may regulate the exercise of Aboriginal and treaty rights, but in order to do so, the Crown must demonstrate that any regulation is justified, whether it's for conservation or other grounds of public importance. And as many of you know, the test for justification, the test for justifying an infringement of an Aboriginal or treaty right is a very rigorous test and a very onerous one. So in Marshall, the court concluded that the prohibitions that had been imposed on Mr. Marshall by the federal fishing regulations interfered with his treaty rights, and the Crown had not provided any justification for the infringement. So he was acquitted of the charges. The court in Marshall also acknowledged that catch limits that could reasonably be expected to produce a moderate livelihood for individual Mi'kmaq families at present day standards could be enforced without violating the treaty right. So in other words, it is possible that reasonable limits could be established that would be consistent with the treaty right to fish for a moderate livelihood. However, again, to date, 21 years after the Marshall decision, no such limits have been negotiated between the Crown and the Sipekne'katik. So it's not an illegal fishery, rather it's a fishery that's been established in accordance with the Mi'kmaq's constitutionally protected rights. The second misconception is surrounding lobster conservation concerns. So much of the opposition to the Mi'kmaq fishery has focused on the potential negative impact of the fishery on the conservation of lobster. Now, the Sipekne'katik have been clear that they take conservation very seriously and are monitoring the issue. They've also clearly stated that the fishery is being regulated in accordance with their own fisheries management plan, which incorporates conservation measures and provides for enforcement of those measures by their own compliance officers. As well, there's been information released by DFO confirming that lobster conservation concerns are unfounded and that lobster stocks in the commercial fishery are healthy. Other fisheries experts have also weighed in, pointing out that given the small size of the Mi'kmaq lobster fishery, it is not a danger to the lobster stocks. So in reality, the main reason conservation is being put forward as in opposition to the Mi'kmaq commercial fishery is because Canadian courts have held that the Crown may limit the exercise of Aboriginal fishing rights for conservation purposes. But, you know, as the courts have noted, in order for any such limitation to be justified, there actually needs to be legitimate conservation concerns. So, and in addition, the court in Marshall had indicated that the Crown would be required to consult with the Mi'kmaq before limiting the exercise of their commercial fishing rights, whether that was for conservation purposes or otherwise. The third misconception that I wanted to touch on was the impact of potential Crown prosecution of buyers. And so in the days following the opening of the Sipekne'katik fishery, Canadian governments issued media statements indicating that they would prosecute anyone who purchased fish caught as part of their commercial fishery. So I think it's really important to understand, and I know that the chief has explained this in the media statements, but any steps taken by government to deter buyers from purchasing lobster from Mi'kmaq fishers directly threatens their commercial fishing rights and the ability for them to exercise their rights. So in order for Mi'kmaq fishers to exercise the right to sell fish to support themselves, they need to have access to a commercial market for their fish. Without buyers, they're not able to exercise that right. So again, rather than honoring the treaties, the Crown's proposed prosecution only serves to further undermine the rights, the Mi'kmaq's fishing rights. And even more concerning, I think, is the impact of recent acts of violence on the ability of Mi'kmaq fishers to exercise their commercial fishing rights. So I think, I mean, I'm sure everyone's aware of the incidents in the last week and a half, the way the conflict has escalated. And I just wanted to touch on some of those more recent developments, in particular on the role of the RCMP and criticism about their lack of responsiveness. I think the remarks by Indigenous Services Minister about the RCMP's lack of intervention are particularly scathing in this regard. I think Minister Miller indicated that the RCMP has let down the Mi'kmaq fishermen by failing to take action. So, and then I also thought it was interesting that the head of the RCMP union has argued that the events taking place in Nova Scotia is not a police matter. So it's hard to understand how acts of intimidation and violence, including assault and arson, are not police matters. And I know that I understand that Professor Roach will be speaking about this issue later in the program, and he's an expert and I'm not. So I'll just limit my comments to the following. First, I think that there's a lot of frustration and questions being asked across the country about the policing of Indigenous peoples. And it's hard not to draw comparisons between the level of RCMP involvement depending on who's being policed. For instance, I know comparisons have been drawn between what's happening in Mi'kmaq versus the level of RCMP involvement in the Wet'suwet'en territory. I read something the other day that stated that the RCMP have spent more than $13 million on policing in Wet'suwet'en territory. And that was to address peaceful protests in response to the construction of a pipeline. And then in Nova Scotia, by contrast, there's a real limit or lack, I guess, of policing resources available. And even more frustrating is that the conflict is being characterized as a fisheries law dispute and not a policing matter. So I think that there's really a conversation to be had there. And then second, just yesterday, the Nova Scotia Supreme Court issued an interim injunction, which I understand now prohibits interference with the Mi'kmaq fishing activities and prohibits threats and harassment of band members or people doing business with them. So I think, like others, I'm sure others feel the same way, I'll be interesting to see the level of response by the RCMP in enforcing that injunction. So those are just some thoughts on the more recent developments and maybe something that we can discuss more. And then I guess just some concluding thoughts. And I think this again goes back to what Lavallee was saying about the importance of this being not just a treaty rights issue, but really an Indigenous sovereignty issue. So by commencing the self-regulated commercial fishery, Sipekne'katik has taken the position that the status quo of unfilled treaty promises is not acceptable. It's no longer acceptable. And I think it's important to note that in addition to exercising their constitutionally protected commercial fishing rights, they're also exercising their inherent jurisdiction to establish and regulate their fishery in accordance with their own laws. And so with that in mind, I think it'll be interesting to see what results from the talks taking place between the First Nation and the Crown in terms of management of the Indigenous fishery going forward. So I think I'll stop there and then we can open it up for discussion.
Thank you so much, Angela. I think, if we were in the moot courtroom all together, you would hear lots of applause and you would have heard us like, yay, yelling to support what you're saying about the, I see Carly doing a clap, the comparison with Wet'suwet'en. There's a wrongful conviction case right now that is out of Nova Scotia where the RCMP in Nova Scotia it's established that they destroyed evidence to ensure that a wrongly convicted person stayed wrongly convicted on appeal. And, you know, Kent and I are going to be talking a lot about that case with our wrongful convictions course in January. So that's an aside. And, you know, it's a challenging time right now for Indigenous folks across the country. It has been for a long time. It's great that it is coming to the public's attention with the Black Lives Matter movement and other activism that is coming during this difficult time that everyone is experiencing because of COVID. But that's enough from me. I am going to move it to the chat for questions. So we have about 10 minutes to ask Angela questions. Lavely could answer questions. I see one question from Manal. Manal, do you want to unmute yourself and ask the question yourself, or would you prefer for me to read it to you? Or read it to Angela? Okay. Oh, a wailing baby. I understand that. This is a public safety matter. It goes beyond policing, which is already structurally racist. How is this not being prosecuted under the criminal code as domestic terrorism? Do you have any thoughts on that? And our terrorism expert, Kent Roach, you could probably chime in as well if after Angela has had a chance to respond.
I'd be interested to hear from Professor Roach myself. So not to pass the buck, but to pass the buck.
Sure. Yeah. I mean, our terrorism laws are, you know, apply to property damage only when it endangers public life. You know, some of the burning of the lobster pound a few days before the lobster pound was burned to the ground, there was a mob that actually, you know, took the lobster and threatened two of the Mi'kmaq fishers inside the pound, including one who was Donald Marshall, who is Donald Marshall Jr.'s son. So yeah, I mean, you know, this is something that there have been a few charges, but certainly not of the level of charging them with terrorism. Canada has a very, you know, poor record on prosecuting far-right terrorism as terrorism. There seems to be a wrong equation that's contrary to the letter of the criminal code to associate terrorism with people that, you know, are inspired by Daesh. And so yeah, I mean, you know, this is another sort of issue. I'm going to talk a little bit more in my talk about some of the dangers of going down that road. I mean, the RCMP is throwing intelligence at Indigenous activists that treat them as kind of de facto terrorists. So I think it's a very good question, and I don't have a complete answer, but perhaps we can continue this in the second half.
Thanks, Kent. Professor Fidel Mohammed, you have a question you want to pose to Angela about treaties and Canadian constitutional law?
Yeah, first of all, let me apologize because, as probably most of you on this call know, but maybe not everybody, I am an American trained lawyer, and so I don't really know the technical jurisdictional questions that arise out of Aboriginal law in Canada as well as I would in the United States. Not that I'm an expert on Indian law in the United States by any stretch of the imagination, but I do know a little bit there. And one of the things that kind of struck me as I was listening to the presentation is it seems like there's an anomalous position for Aboriginals treaties in Canadian law as compared to how I understand treaties function ordinarily. So in the case of non-Aboriginal treaties, like Canada enters into a treaty with the United States, like NAFTA or USMCA, that creates an international obligation for Canada, but then the federal parliament or the relevant provincial parliament implements legislation to give effect to that treaty in the domestic legal system. So I don't understand exactly how Aboriginal treaties work in terms of the domestic Canadian legal system. Are they what we would call self-executing treaties from the perspective of public international law, in the sense that they confer rights directly on the relevant members of the bands, so that there doesn't need to be some sort of written codification of those rights in the positive legal system? So a part of what we're seeing, just because there's a kind of indefiniteness to the nature of the rights because they're not enshrined in positive statute. I mean, if one wants to take an optimistic view that this is this conflict is a result of the ambiguity of the rights because they're not specified by statute, or is it, you know, so is that sort of like the end game, that we want to have, like Nova Scotia, or whoever the relevant regulator is, to have a codification of these rights so that, you know, the property rights are very clear, and then it's very easy for public officials, whether in the fisheries or the RCMP, to protect these rights. But I think you have to start off with the idea of how do these rights become recognized in the internal sort of background legal system.
Thanks so much for the question. Yeah, I think your question hits at a lot of issues that come up in terms of not just treaty rights, but Aboriginal rights, but particularly in the treaty context. So I think I have a few, just a few comments that I wanted to make in response, I guess. First is that the treaties themselves, the way they are viewed by the Crown and by the Indigenous signatories is often with a major difference. So many of the treaties, these peace and friendships are one, and then there's numbered treaties. I should say many of the historical treaties are often treated by the Crown as being surrender treaties, where the First Nations, the nations that entered into them surrendered their rights, their title. Well, they recognized certain rights, but surrendered their title to the land. So that's how the Crown often treats them. So the level of recognition is narrower, and often they will wait until the court makes a determination that the right exists and has been recognized in the treaty before they take any steps to actually implement. From the Indigenous signatory side, that's not the case at all. The treaties that were entered into historically were a lot like the peace and friendship treaties, meant to establish alliances, maintain peaceful relations, and share the land. That comes a lot, especially with the numbered treaties that would have followed the peace and friendship treaties. So the heart of the conflict really is this different perspective on what the treaties meant, what their effect was, and the Indigenous jurisdiction that survived, or according to the Crown didn't survive, following the treaty. Then in terms of how that fits in with Canadian constitutional law, in 1982, the constitutional amendments that took place in 1982 actually included a provision, Section 35, whereby all existing Aboriginal and treaty rights were recognized and affirmed. So by that inclusion, the treaty rights set out in these historical treaties, and any Aboriginal rights, because Aboriginal rights aren't tied to treaty. Some treaties were put in place across Canada, and they recognized recognized existing rights, but Aboriginal rights existed outside of treaty and before contact. So by entrenching it in the Constitution, these rights became constitutionally protected. So it's just a higher level than being codified in legislation. So that's the significance of I guess, or I think one of the main differences. I'm not too familiar with the American situation, but that's the situation here in Canada in terms of how those rights play within the constitutional framework. I hope that helped clarify.
Thank you so much, Angela, and thank you, Mohammed, for your question. I think we probably have time for one more question, Angela. Does that make sense before you have to go to your next meeting?
Yeah.
I don't see anyone else in the chat. Do any of the Indigenous students have questions for Angela? I also see a lot of our allies here. Oh, Hannah Amal, you have a quick question. You can unmute yourself and go ahead.
So hi, thank you for this, Angela. It was a fantastic talk. My question is, has a genuine stakeholder engagement been suggested as a way to deal with the issue, where both the sides are just brought on a table and made to speak to each other, that let's just come at a resolution, let's just not keep attacking the Indigenous, let them sit together and talk, as a, maybe dialogue as an option? Has that been explored?
Yes, thanks for the question, Hannah. Yeah, I believe that the First Nation and the Crown are in discussions. I don't know much more than that. And again, the hope is that they can arrive at some form of co-jurisdiction where I don't know that this is what the discussions are or what the intention is, but I know for a lot of our Indigenous clients, that's the goal, is that they want to arrive at a place where there's both levels of government and jurisdiction managing the resource. Thank you.
Thank you.
Thank you so much. And that's such a great question to end on, because it alludes to Indigenous law and the way that things probably should have been done from the beginning so that we weren't in this situation in the first place. But that's the beauty of Canadian law. Angela, thank you so much. I don't want to keep you longer. Oh, Nicole has a question. You know what, Nicole? Angela, do you have time or do you have to run?
Yep, sure.
One more question. Okay, Nicole, go ahead and unmute yourself.
Thank you. I'll try to be brief. I'm just wondering if at any point between the time the Marshall ruling came out, which I believe was 1999, until now, if we've come close to having a legislature address this issue. One would assume that maybe when the Supreme Court first ruled on it, there was some talk about it. If you can maybe comment on that.
Yeah, that's a good question. And I'm not going to admit that I'm not too familiar about I know there was some attempts that came out of the Marshall decision, and others might be able to step in here. But the initial reaction following Marshall was one of violence. Again, like what we're seeing now. Following that decision, some Mi'kmaq fishers did go out and start fishing for a moderate livelihood, fishing lobster. And it wasn't eel, it was lobster. And that caused the non-Indigenous commercial fishermen, again, to react very violently. And I believe even DFO was involved at the time in terms of trying to prevent the fishermen from exercising their rights. And then there were, I don't want to misspeak, I know that there were some regulations issued to address Aboriginal fishing, but not this question of moderate livelihood. That has remained outstanding. And others may have more information. Please jump in.
I don't have any more information, but if folks do after the break, we could talk a little bit about that. Manal says we're talking about 150 lobster traps as opposed to 390,000. So that is worth wailing about whether you are a baby or not a baby. Okay, well, I will let you go, Angela. Thank you so much. We're so grateful for your time. We're so grateful that you did this at the last minute. You know, we said earlier when everyone was in the waiting room, we're hoping that this is the first conversation, and we would love to have some folks from the community come and speak about what it's been like from their perspective. So we'll be in touch again very soon, and good luck this afternoon with your meeting.
Thank you so much, and good luck with the rest of your day.
Thank you very much. Okay, so for everyone else who's sticking around, we are going to take a quick 5-minute break. Before we do, I wanted to let you know that just yesterday, if you're not following me on Twitter or following the Indigenous Initiatives Office, Human Rights Watch released a new report that I'm putting the link in the chat for you that you might be interested in downloading. The title of the report is "My Fear is Losing Everything: The Climate Crisis and First Nations Right to Food in Canada." The findings of the report are entirely connected to the topic that we're dealing with today and go into climate change. And it's about how important it is for Indigenous people to be able to harvest their traditional foods, to be able to live off the land in the way that we have since time immemorial. I've asked the authors of the report to come later in the semester and give a presentation on it. But in the meantime, I wanted to put that in front of you, and I encourage you to download it and take a look. There's also a beautiful video that they've made with the community on the James Bay coast. And with that, we are going to take a 5-minute break. We're going to come back at 1 o'clock sharp, and Professor Roach and Elder Constance and the Indigenous students are going to lead a conversation about the RCMP response and more generally the relationship between Indigenous communities, RCMP, and other police forces in Canada. And we're going to talk about some of the steps that you as students, staff, and faculty and friends of the law school might take to support the community in Nova Scotia. So feel free to put yourself on no camera while you take a break, and we'll see you back at 1 o'clock. Merci. Okay, everyone, I have 1 o'clock on my clock. So Professor Roach, I'm just going to answer your question. We'll put it in the chat as soon as you're ready.
Okay.
So just let me know, and then we'll start. Is Elder Constance back? Hi, Karen. So nice to see everyone. Hi, Rachel. Hi, Brandon. Okay, Elder Constance is still, so we'll give her another minute to come back. I don't want to start without her. While we're waiting to start part 2, does anyone have any questions for Professor Roach that pertain to part 1 of the presentation? Building on Mohammed's question, I'm curious to know, and this is, maybe a difficult question, but how the modern treaties are they legislated, or how do they work legally?
Well, I mean, my understanding is that under Section 35, they become part of the Constitution. So Section 35 is pretty clear that all treaty rights are protected and land claim agreements will become treaty rights. And Section 25 of the Charter is also important because it provides that all of the rights in the Charter should be interpreted in a manner consistent with Aboriginal and treaty rights under Section 35 of the Constitution Act 1982. So, I mean, my understanding has, you know, and when Mohammed asked the question, I actually got my copy of Hogg up off of my floor, but I've always understood treaty rights as constitutional rights by virtue of Section 35, and I consider all of our treaty rights part of our Constitution.
Well, I hope that everyone does, but I doubt that that's the case. Let's end on a positive note, that part though. Great. Okay, well, I see Elder Constance is back, so let's go to part 2 of the presentation, and I'm guessing that you two have spoken amongst yourselves in terms of what's going to happen. I'm not going to micromanage it, so Kent, are you going to speak first and then?
Sure. Yeah. I'll speak first just to give a little bit of background, and then Elder Constance can share her wisdom with us. So thanks, Amanda. Thanks, Indigenous law students. Thanks, Elder Constance, for getting us off to a good start. I'm going to focus, I think, on the RCMP because the RCMP is really the police force that is not keeping the peace as well as we would hope during this conflict. For those of you who are in the Asper Center's group on this, you should know that Senator Murray Sinclair is filing a public complaint about the RCMP's response. Especially in the early days, my understanding is that the RCMP has now sent more people to the community. But Justice Sinclair has filed a complaint. As Angela mentioned, the Minister of Indigenous Service said that the RCMP had let the Mi'kmaq down, although the Nova Scotia Minister of Justice replied that they were basically being concerned for their own safety because they were outnumbered by the non-Indigenous fishers / mob. And Commissioner Luckey, the head of the RCMP, has defended her force's performance. So we'll see where Senator Sinclair's complaint goes, but for those of you who have studied the RCMP complaints and review commission, it's a very powerless body. So not only does it not have power to impose any reforms on the RCMP, but it cannot even release its report until the RCMP approves it. And I think that they have over 300 reports that are waiting to be approved, including the report by Colton Bushy's family about the way that they were basically treated as criminals when the RCMP informed them about Colton's Bushy's death. Okay, so the RCMP obviously has a long history, and like Canada, it is a colonial history. RCMP officers accompanied many of the treaty commissioners when the numbered treaties were signed. The historical record, as such as I know it, is kind of mixed, that there were some Cree chiefs and others who looked to the Redcoats, as they were known, as a possible protector from a kind of lawlessness that was going on in the United States, where others, particularly after the 1885 uprising and the RCMP's role in putting that down and leading to the public executions of 8 people at Battleford, many Indigenous people turned against the RCMP. As you may know, the RCMP, although a national symbol, is, I think, a deeply conflicted one for Canadians. And, you know, many Canadians think of the RCMP, as I did growing up, as the musical ride, the Red Surge. Even the Red Surge is actually, I think, problematic because it was based on a military uniform. And the RCMP was very much historically set up to follow the Irish Constabulary, which was another colonial paramilitary force, as opposed to, say, the London Bobbies, who were seen more, as Sir Robert Peel would argue, as the police is the public, and the public is the police. An instrument of colonialism and colonial oppression, as I said, enforcing the pass system, which required approvals to go off of reserves, again, because of this kind of concern that Indigenous people would essentially act as terrorists, and also enforcing attendance at residential schools. Angela did a great job of talking about the Marshall case, but I just want to add, you know, just one or two things. After the Marshall case came out, and of course Donald Marshall Jr., Mi'kmaq leader who had been wrongfully convicted of murder, served 10 years, risked a lot by being the person who was then subsequently arrested for fishing eels worth, I think, $787. And violence broke out around a place that used to be called Burnt Church in New Brunswick. And the non-Indigenous fishers asked the Supreme Court for a clarification of its rulings. And, you know, having been involved in a lot of Supreme Court cases, and I know you as students, it would be really nice if you could ask courts to clarify what the heck they meant. But courts generally or never do that. In this case, they did, and they issued, I think, an astounding and regrettable 42-paragraph reinterpretation that said, oh, you know, nothing that we said in the first judgment, which, as Angela said, affirmed the right to commercial fishing to a moderate livelihood. Nothing that we said in the first judgment precludes limiting treaty rights, even though there's not a reasonable limits clause in any treaty that I'm aware of, limiting treaty rights in order to, you guessed it, protect the interest of non-Indigenous fishers. And of course, as has already been mentioned, in the lobster fishery, the Mi'kmaq lobster fishery is a very small percentage of the whole fishery. The Mi'kmaq boats, in this case, I think at most carry 50 lobster traps when they haven't been seized by DFO or destroyed. Commercial fishing, commercial lobster boats carry about 350 2050. So one of the things about getting old, and I'm getting old, is unfortunately you see history repeating itself. So Amanda, can you either play or show people a clip from the CBC News that shows what went on in Burnt Church after the first Marshall decision, which was over 20 years ago. So I'm imagining most of you did not watch this on CBC 20 years ago.
They
But
were
if you
probably
did,
not born yet.
yeah, we're not.
So I've just put the link in the chat for everyone. I think instead of trying to play it for everyone to watch through Zoom, which is not going to go well with 81 participants, you can just mute and turn your video off and then watch it yourself in your own browser, and we'll come back. It's only 3 minutes long, so we'll come back in 4 minutes and we'll continue Professor Roach's presentation. Please make sure you're muted so we don't have echoes.
So I'm not going to do that, Ken, because I'm not technologically proficient. And I'm so afraid of losing this Zoom conference. But I know what you're speaking of, because I too am old and carry that in my memory bank.
Amanda, will you tell me when we're going to go back?
Yeah, I just finished, so we'll give everyone 30 more seconds because I think I started late. That is a very powerful clip that I did not watch earlier when you sent it to me, and it's infuriating. And bananas that history repeats itself in such an evident way. Also, I didn't know that if you throw a rock at someone, it justifies running your boat over their boat. News to me. I see most people's faces are back, so why don't we continue? Go ahead, Ken.
Okay. So yeah, so I mean, I can tell by the reactions that, you know, many of you are, you know, rightly disturbed by this. But I kind of put it up for at least two reasons. One is history is repeating itself, although I guess there's a little bit of an improvement because the DFO, Department of Fisheries and Oceans, is not, to my knowledge, using that aggressive form. Some of you have asked whether anyone was charged from that. So far in my research, I've not found that. It's kind of an ongoing research. So one is the history lesson, is that you know, the Marshall decision has been around for a long time, but people don't understand it. Governments have not acted upon it. You know, the fact that this is happening after 20 years is intensely frustrating. But the second thing, and you know, this is, I think, really important to understand and has already been alluded to, is Indigenous people suffer the extremes of over-policing and under-policing. And what you saw with the ramming is an example of over-policing. And just, you know, not to put a too, you know, some people, including some academics, wrote op-eds saying that there should even be a stronger response than that, which, you know, really just kind of baffles me and makes me shake my head. So you have over-policing that kills Indigenous people or puts their lives at risk. Certainly as a non-swimmer, that would have put my life at risk. And then you see under-policing. Of course, missing and murdered Indigenous women is a prime example. But also this idea of being unprepared and outnumbered by a mob of non-Indigenous fishers who acted, you know, in violation of Canadian law with respect to property damage. I would think, although obviously I'm not an expert on Mi'kmaq law, but one of the things that they did is left many of the lobsters that they stole from the lobster pound, left them on the ground to die in a way that is not respectful to the lobster. And so, you know, the issue is, how do we get away from this vicious circle of over-policing and under-policing? And I would say that the root of both of those are bad relations, lack of understanding, and colonialism towards Indigenous people. Now, it was mentioned that an injunction has been obtained by the First Nations, and I haven't been able to find the written injunction. I can understand why that is done, but, you know, again, that relates to over-policing. Because those of you who have to suffer through my legal process course know that that injunction is what is used to arrest people at Indigenous defense of land, including in the BC GasLink dispute. Angela mentioned that 13 million was spent by the RCMP on that. in New Brunswick, in a shale gas protest by the Sipekne'katik First Nation in 2013, where over 40 people were arrested. Again, this kind of military, paramilitary, camouflage, helicopters, $12 million were spent. So it'll be interesting to see what happens with this injunction, because the injunctions have been the setup for the RCMP when it comes to blockades to go in hard and in a militarized way. Now, the last thing I want to say before throwing it over to Elder Constance is that I think that this lack of equality will make you angry at the police. And I'm not going to deny that I'm angry too. But I think it's also important to recognize that the police do not have the solution for this problem, as is the case with many of the problems that the police are dealing with. They do have an obligation to enforce the law equally, to enforce the rule of law, and I would say that's not only the criminal code, but the Constitution of Canada, which includes treaties. But this requires something more than policing. It requires nation-to-nation negotiations. It requires public education about treaty rights, and it requires a lot more. So for sure, be critical, but I don't see more policing necessarily as getting to the root of this unfortunate problem, which is also an example that we've seen too often of a brutal history repeating itself for Indigenous people from coast to coast to coast. Thank you.
Thank you, Kent. I just want to say a word of appreciation, not only for the knowledge that you carry, the deep knowledge that you carry in these matters, but the passion of your heart, that you stay the course on reflecting upon these matters. And that is a big commitment, because these are not easy times. And so my thoughts that are coming to me are kind of all over the map, but I want to start off by saying the RCMP was first formed as to solve the Indian problem. That was the commissioning of the RCMP. And these things that are going on here in the 21st century are unconscionable. As we are more educated, not only are we more educated in terms of academia, but we're more educated in terms of the human condition and human relationships. And I don't see this as a repeat of history. I see this as a continuum of these original histories. And my ire is up when I see my people suffering every day in every way. And I want to make a note that I have a 40-year career in addictions, mental health, and trauma work with Indigenous people. And I'm a Métis woman from northern Saskatchewan whose family, both sides of the family, fought against one another at the Battle of Batoche. And those wounded feelings and intense feelings continue to exist. What is that? So now you're students and you're learning the craft, you're learning the tools to implement your knowledge into the legal system. And so my feeling is to say words of encouragement to you, each and every one of you, that once you carry knowledge, you can't unknow the knowledge. And you can see that these issues are very long-standing and very complex and inequitable. And so on the one hand, it's good to have the privilege of having an academic education. And on the other hand, it's good to have an activist's heart But it is more wise, I think, to invoke your critical thinking skills, to stand back and have that eagle eye overview of all parties. But not only that, to have that eagle eye overview of the continuum of histories upon first contact. And that you invoke the knowledge not to be an activist to go march on the street, because maybe that doesn't necessarily apply to you, but definitely to carry the knowledge that you now have, incorporated into your craft as you walk forward. It doesn't mean that anybody has to be radical or loud, because that also is not productive. But to be an activist is to carry the knowledge and utilize it in your craft, to speak to bureaucracy, for which the Indian Act and these matters are mired in bureaucracy, that you apply your craft that way. And when the opportunity arises for you to, with wisdom, with knowledge, with strength, with courage, assert yourselves in a peaceful way. For the ultimate of these conversations, the ultimate of the education, and the ultimate for us to walk forward as Indigenous people and allies is to create a win-win. So I like this one student that asked, can this not take place during talks? Because as an Indigenous woman, traditionally that is our way, is that talking circle where everybody has an equal voice and every voice is heard, so that the elders can reflect, support, and guide towards something that is livable for all. So I hope you can hear the passion in my heart, but I also hope that you can hear from me a voice of encouragement towards you. Thank you very much.
Thank you, Auntie, so much. And thank you, Kent. I'm now gonna hand it over so we can do questions if folks have a few questions, but I'm gonna let the Indigenous students moderate those questions because you're sick of hearing my voice. So Tomash, I don't know if you want to take over, or Carly or Lava, I'm not sure who is going to give folks the opportunity, or we could, someone has a question for, I'm assuming you mean Kent, on reasonable limits. So we can definitely answer a couple questions. Okay, now I'm actually not going to talk anymore.
Okay, I can moderate these. We can go with your question, Rolf. I can't tell where your first name and last name end, but you can unmute yourself and ask your question.
Yeah, it's Rolf Gerstenberger. I'm not a student. I'm a retired steelworker from Hamilton. No, I just had a question for Kent. There was a little intervention about reasonable limits, and the question isn't the way the government puts in the reasonable limits, isn't that through the charter? You know, the 1982 Charter of Rights and Freedoms. I think it's the first or second sentence says everything following has reasonable limits. So aren't they applying that to all these treaties too? Or how does that work?
Thanks, Rolf. That's a good question. I mean, basically, you're definitely right that reasonable limits in Section 1 applies to all of the charter rights, but you know, lawyers can be kind of sneaky, and Section 35, which is Aboriginal and treaty rights, is actually not part of the charter. So the Supreme Court has asserted, and it is very controversial, that basically a similar reasonable limits applies to Aboriginal and treaty rights. Now, of course, you know, the problem is as in this case, if you sign a peace and friendship treaty in 1752 or 1760, as occurred with the Mi'kmaq and the British Crown, there was no reasonable limits clause. So the legitimacy of the Supreme Court reading that into especially treaty rights, I think, has been contested. And the Supreme Court, in its, very extraordinary, it's the only case I know where the court has basically backed off and reinterpreted its decision as part of its own decision. My understanding is that that's really not been picked up. Because the legitimacy of the limitations is contested. Even on Supreme Court doctrine, cases like Sparrow, which involve commercial fishing rights, talks about priority being assigned to Indigenous uses. And I think we're a long way from priority here. And of course, the new thing, which a lot of people were not talking about, and because of the important work that John Burroughs and Val Napoleon and people at Victoria and elsewhere have done, is that I think now we have a greater awareness that Indigenous law itself provides a means to regulate and limit harvesting. And that was one of the reasons why I was really kind of captured in reading the recent press by the fact that when the non-Indigenous fishers went in, they just wanted to destroy the lobsters that were in the pound. They may also have been incorrect in thinking that they were lobsters caught by Indigenous people. But by leaving a catch on the ground and by cutting hydro that prevented lobsters receiving oxygen that they need, this itself is something that I think would be handled differently under Indigenous law, although I obviously, as I said, am not an expert about Mi'kmaq law. But to go back to what Elder Constance said, I too agree that this needs to be resolved not by police, although there is, I think, a very serious argument that if we're going to have police, they have to police equally, and what's sauce for the goose is sauce for the gander. But at a table where hopefully people will appreciate that Indigenous people from time immemorial have taken conservation seriously and have built that into their own laws. And so again, this kind of goes back to one of the things that Angela said, is that if you go back to the 1752 and 1760 treaties, they're more like international diplomatic treaties. And when we have international diplomatic treaties, we try to respect each other's legal system. And I think that, in addition to kind of the racism and all that's coming from some of the non-Indigenous fishers who are really, disrespecting their neighbors, we also have a lack of understanding of Indigenous law, both at the level of the non-Indigenous fishers, but also at the levels of the governments. And I think that it's only if we respect Indigenous laws as a means to limit rights, because everyone accepts that it doesn't make sense to fish out the lobsters, but again, most of the evidence that I've seen, there's a good recent article on The Conversation by a fisheries scientist at Dow. They're saying that the Mi'kmaq lobster fishery, even though it is being done in a season that is not open for the non-Indigenous, is, in their expert views, not going to endanger the lobster stocks. So, again, I think the lobster have not been particularly healthy and robust, and this is probably one of the things that is driving the non-Indigenous reaction.
If I can just continue that part of the conversation, long before contact, the Indigenous people of Turtle Island had relationship to the land, had relationship to the animals. I'm 70 years old. I can even remember a time when the Great Lakes, the water was clean. All the lakes and rivers, all the water of Turtle Island was clean, that the land was abundant, that the animals were prolific. And it is in our cultural and our traditional ways that we follow the 13 moon teachings, and we adjust our lives according to those 13 moon teachings, which governs which part of the season we do what we do in each part of the season. And following those traditional teachings is the self-regulation and is the management of the land and the animals and the fisheries. And I struggle to understand, well, first of all, the Indian Act was a very colonized act which took the Indigenous people of this land, treated them as stupid children that were not trusted to take care of their own or themselves or take care of the land. So it was very patriarchal. And that continues to exist, although great work is being done to unpack that and break it down. I fail to understand if this is at a federal level, how come these things have been settled for the West Coast Indians, and that there is relative peace and people live together and fish and hunt on the lands on the West Coast. That on the East Coast, it's somehow different. If we're using the RCMP and we're using the federal government, why is this so unevenly handled? I really struggle with that. So it's like they're in silos. And so one part of the silos can claim ignorance, lack of understanding and lack of knowledge, whereas on the other parts of a silo, there's conversation, the energy flows, there's allyship, there's conversation back and forth, like in a traditional talking circle. And those relationships are strong and developed and respectful.
Thank you, Professor Roach and Elder Constance, for your insights on that one. Emily, if you want to unmute yourself, she has a question for you, Elder Constance.
Hi, thank you for being here. So I'm wondering, in your talk, you mentioned that the answer is not to be radical or to be loud. And I don't want to take that out of context because I think I understand what you mean. But I was wondering, in terms of the radical piece, if you could speak a little more to that. What's in there that it's not the solution to just be radical?
Well, being radical is a really important part to having our voices heard, and standing up in a public way is really important. But getting into a mindset of us and them, that againstness, to my way of thinking at my stage of life, seems unproductive. So although I think it's really important to march, I think it was really important to stand shoulder to shoulder. I'm thinking about, when I made that statement, I was thinking about, about becoming a lawyer and practicing law. There's a conduct of civility, of politeness, of respect, and a manner of conducting yourself. And I was thinking, as practicing lawyers, when you get that call to the bar, however you go forward, that should be incorporated in your license to practice law, of how you conduct yourself. And yes, standing up and marching is vitally important. I was speaking more towards the balance of the knowledge that you carry, the tools that you use to practice your craft, and an activist's heart, so that it doesn't have to look like marching in the street. It doesn't have to look like shouting voices, although it can, and that's very valid. But it can also look like using wisdom and civility to press your point, to stand up, to stimulate the bureaucrats to get out of their sleepy heads, and to invigorate the bureaucrats to understand the full meaning of the intent of how these things were written down, how they are to be practiced, so that they're not just in a comfort zone of so much bureaucracy that they can, you know, send off rabbit trails here and there, to send our people in a bureaucratic chase. I mean, I'm thinking about, you know, Mr. Donald Marshall Jr., although he won his case, what the federal government did is they gave the, I'm maybe not using the right words, but the monies given in the settlement of that case were dished out to him at a level that it would have been were he receiving welfare as a single man. And so he, in fact, died in poverty, and put his family were put through just terrible, terrible poverty. That's a bureaucratic shuffle. And I'm saying to you folks that with some wisdom and all that knowledge, it can be different, it can look different, and that too is activism.
And I mean, if I can just add, I mean, I've started a book on policing, and you know, I certainly hear the Black Lives Matter and calls for de-policing and defunding, and I think there's a lot to that. But I also think that events like this, or when you have armed right-wing protesters, and you know, really raise some basic questions about whether we want to arm both sides, or whether we want to have some peacemaking force in between. Now, you know, I also think that we need more First Nations and Indigenous police services. And I think that if they were given sustainable funding and freedom, that they could actually teach a lot to Canadian police forces. But I have to say that although, you know, I wish I could live in a world without police, some of these things do raise the question of how are we going to contain violence in this increasingly polarized and fractious world. And like Elder Constance, I mean, I guess I'm of an age where I understand why young people are so frustrated and so concerned about their futures, and, you know, look at institutions and want to completely redo them, and I applaud that. But I think we also need to think about, what do we want the police to do? Do we want someone to protect against that sort of violence? And then where do we proceed in order to prevent future violence like that, and hopefully to come closer to resolving the underlying conflict? Because although, you know, the video I showed you, like so many videos, is, you know, in some ways inflammatory, and that's driving a lot of the debates, I'm also finding in my research, you know, some signs where some police officers did some good things. And, you know, I found a story about a police officer who was brought to New Brunswick from Newfoundland, and it was just him and someone else in their boat, and they kept the Mi'kmaq and the non-Indigenous fishers apart. And of course, you know, that I think is better than shooting at each other, which is something that actually happened on the waters. And I think Chief Sack has a memory of that when he says we need people out on the water because on the water it is very dangerous. So although there's a lot of things that happen when we turn the cameras on that justifiably makes people angry and makes people question, why do we even have the police? I think we also have to think about what happens when the cameras are not on, and what happens when people and their families are threatened and feel that they cannot even earn a moderate livelihood for their families because of fear and intimidation. So there's no easy answers, but I think I understand what Elder Constance was saying, that, you know, radical in your hearts, but we also have to realize that we can't just get rid of everything, that we need to build something. And I think lawyers have a role to play in that.
Thank you both. I see we have 2 more questions from Nicole and Alexander, but I do want to get to the action piece before we run out of time. So Professor Roach, if it's okay with you, maybe they can just email you their questions and ask them that way. Perfect. So then I will pass things on to Tomasz. He's one of our first-year Indigenous students, and he's going to go through some ways that you guys can offer some tangible support to the community.
Thanks, Carly. Thanks, Amanda. And thank you to Elder Constance, Angela, and Professor Roach for their words and knowledge that you've shared with us today. What we figured we would do now is take some time to invite our guests to channel some of their thoughts and ideas that they've had about some of the knowledge shared with us into some opportunities for allyship, one of which is letter writing. So what I've just done is posted the links to 2 Google Docs in the chat, one of which will take you to an example of letter format or letter writing. And if you click on that document, it'll have a formatting guide for those of you who might not be sure about how to write a letter or the purpose of a letter writing. The formatting guide is also included in there, and that'll include links to other sites where you can find more information on what's happening right now. And at the bottom of the document, you'll find a list of possible addresses and people who you can get a hold of with those addresses, or who to send your letters to. Finally, we'd also like to acknowledge that there are other ways to contribute as an ally to this topic, including financial donations or donations of physical supplies, which Mi'kmaq are asking for. And a link to that Google Doc has also been sent into the chat. So we'd like to take maybe the next 10 minutes, if you guys want to like close off your cameras, to look at some of the ways that you can be an ally, go through the letter writing document. Feel free to write a letter. If you have questions, ask us in the chat now, and then we'll come back in maybe 10 minutes. Thanks.
So Amanda, I would just again like to put it out there, if any of the students want to follow the conversation forward with me, that they can reach me through you, and we can either do a telephone, a Zoom, or an email conversation if people have more specific questions in my direction.
That is a great idea, Auntie. And for the first year students who are going to be doing the sharing circles about the books soon, we're going to give you opportunities to have one-on-one appointments with Elder Constance as well. So anyone who wants to follow up with Elder Constance, send me an email, and it's amanda.carling@utoronto.ca. In case folks need to leave a little bit early, I don't want to distract you as you're writing your letters, but I did want to quickly let you know that next week, the Asper Center is hosting a roundtable discussion with Professor Carrie Wilkins on implementing UNDRIP, which certainly will not solve immediately all of the problems that we're talking about today, but like many things, it can't hurt to try. So I'm going to give you a link to the registration and information about that event as well in the chat.
And Amanda, I have to teach at 2:10 with my legal processes, so I'm not sure if I'll...
You can write your letters later, Kent.
Okay, thank you. Thank you.
And if you're signing off, I know Carly's offline, but thank you very much if you have to get going before we come back.
Yeah, I probably should prepare a bit.
Okay.
Pleasure to see you, Kent. I look forward to our next time sitting together.
Absolutely. Thank you, Elder Constance. Thank you.
Thank you,
Bye-bye.
Kent, for joining us.
Bye.
Okay, so we are almost at 2 o'clock. I know we didn't have as much time for the letter writing component as we would have liked, but I'm glad to see that people were engaged with our speakers. So I think what we're going to do is post those templates onto Facebook for all of you. So if you want to check out the Indigenous Law Students Association Facebook page later, I'll make sure those are posted there so that you guys can pick up this later. So Elder Constance, if you don't mind hopping back on and closing us off before I say goodbye.
Thank you very much. It was a pleasure to sit with you all. I would like to do a closing prayer, and I hope as we go forward that the dialogue will continue, because your dialogue, you carry power, your knowledge and power that you're carrying. We continue this conversation going forward. We can make changes, and we can make this look like 21st century human conditions. So again, I'd like to say, Creator, Ishnikawapi Meingumkwe, Makwadodam, Waniwachi Elo Ate Omakiayo, saying to Creator, I am White Wolf Woman, I am Bear Clan. I say that prayer of, I want to walk forward in my life in beauty and grace of being present with you. And I am but a pitiful creature, just a small, insignificant human being, asking Creator to walk with me and the ancestors to guide my footsteps and help me walk forward in a good way. So The medicines have been burned. The water was spilled. That tobacco was laid down. And asking Creator to walk forward with us all. Asking the ancestors of this land and the ancestors of our Mi'kmaq brothers and sisters to guide our footsteps forward. Asking the grandmothers of our ancestors to join each one of us in our sleep time and press down on our hearts so that in our dream world we can join them at their fire and they can show us in visions and they can teach us with their song and words our way of beings. And also asking Creator as we walk forward that our hearts be joined to our minds so that each one of us can know and understand the power of speaking in our individual authentic voices. And ask a great blessing on these students. This being a student is a huge commitment. It is a struggle, but it is a glorious struggle and a privilege. And asking your blessing on each one of the students present here today, or each one of the students that may in the future see this and hear this. I say, Matakwiyash, all my relations. Hi, hi.
Miigwech, Elder Constance, thank you so much for joining us today. It was so great to see you. And before we all sign off, I just want to say a quick thank you to everyone for taking the time to join us today and showing up for the Mi'kmaq community. This event was put together on short notice, but a huge thank you to all our speakers for making it happen. Elder Constance, Angela, Kent, Lava, and Tomasz, as well as those who helped organize, promote, and moderate the event, especially Amanda Carling. We're so lucky to have you. It was really amazing to see so many people turn up as well. We had a great turnout, and it's great because it's such an urgent issue. And so it's amazing that you all made time to come today. If you do have any questions come up later on, you can always reach out to any of us. Me and Tomasz are going to stay on for a little bit in case you do have questions about the action items. But otherwise, Miigwech, take care and keep all eyes on Mi'kmaqi.